Okay, guys. Hello, hello. This is a very exciting. This will be the next litigation series video. I believe it'll be part 5. And this one is going to be the first of me breaking down a 2.0 litigation. We have a bunch of these coming down the pipeline, maybe by 10 or 11 of them. And this is going to be my new 2.0 tester lawsuits. Many of them are going to be going to state court. There's going to be a bunch of other things too, but it's going to be basically, I think this video should have been the last video on the 2.0 course before the closing. So I think I'm actually going to put this one on the 2.0 course series. It's sort of like a grand finale, putting all the pieces together and kind of showing how it all fits together. So it's been about a month since I released the 2.0. You guys have been loving it. All my traffic and all my statistics have gone up 3 to 5x on literally everything. So I'm glad that you guys enjoy the 2.0 course so much, and I'm glad that you guys are getting a lot out of it. We've got a lot of people getting free cars right now. We have a free car bonanza. I think 10, 15, 20 cars already, and we got a lot more in the pipeline. So a lot of excitement on that. Great to see that. Great to see people discharging a lot of debt. A lot of people getting passports. Just a lot of activity happening after 2.0, which is exactly what I wanted to see done. So I'm very, very happy to hear that. I put on a silly hat for you guys today. I thought you guys would enjoy this. Didn't really feel like dressing up or anything like that. I've been busy, just putting together some lawsuits and also taking some time off. So I appreciate everything. I appreciate all the sharing that you guys are doing. I appreciate the fact that you've been putting a lot more comments on YouTube and not messaging me or emailing me directly, which has been very nice, very, very helpful. It's allowed me to take some time off and do some other things. So let's go ahead and dive into this. This is the very, very first 2.0 version of the litigation. So this is a brand new style. And what it's going to do is it's going to put everything that you've learned in the course, this course 2.0, all together into one visualized package. So you can kind of see how I do everything and how I'm doing everything now. Now keep in mind, this is 2.0. There could be a 3.0, a 4.0, a 10.0, a 29.0. I'm just going to keep switching things up until we start winning cases. So this is 2.0. I think it's a huge improvement over anything I've done in the past. So I will walk you guys through everything. Okay, so here's the summons. We took this one to state, to a state case. So I wrote I went down to the local courthouse here in Glendale, and the lady Teresa was very, very nice. She helped me. I had a summons that myself and Joey had created, but she didn't like that one too much. She didn't think it was going to work very well. So we went ahead and she gave me another one and told me, kind of like, so basically they can't give you legal advice. What that means is they can't tell you what to do about your own legal situation, but how to fill out a form or major procedural aspects, like how to fill out a form or which form to fill out, that's not giving you legal advice. So legal advice would be like, oh no, that wouldn't be the correct cause of action. You'd actually want to use this cause of action. Or, oh no, you shouldn't have, wrote that particular thing about that particular cause of action. Or telling you something about your complaint that you should have done differently, that you didn't do. Those kind of things would be defined as giving legal advice. Okay. So as long as you're not doing that, they're very helpful and they will help you. If you're trying to get advice on your complaint or the points of your complaint or causes of action, they will not assist you with that most likely. Okay. So she was able to help me with the procedural non-legal advice aspects of this, such as, she wanted me to fill out a different summons and put the defendant here and the plaintiff here. And then she stamped this after I paid for it. Here is the name, and here's the P.O. box. And then she assigned me to the Alhambra courthouse. You can see that here. This is not that important. I'm just going to go through this anyways. This is the cover sheet, just like you've seen in a lot of the federal cases, just some basic information. What are we looking at here? It's an unlimited civil case, which means it's above $35,000, right? What kind of case is it? Now, you got to look here. Check one box below for the case type that best describes the case. So I know this can be very nerve-wracking and very confusing, but the thing is that you don't need to worry about it too much. This is just what kind of generically gives this thing, a pretty good idea. Now, in California, they have a whole addendum sheet, which I'll show you here. And the addendum sheet has an even more detailed breakdown as to all these different types. And I went through and I messed up there and I checked the wrong one. And then I went through and I found this one here, other contract, 3701, contractual fraud. And that's where I got this 37 on the main sheet here. That's why I checked other contract 37 here. So sometimes you can backfeed things. If you're not sure which one would fit and there's some sort of an addendum or something like that, you can go look at that. And then, oh, look, it's got this greater breakdown of each type. Pick the one that applies. Negotiable instruments was selectable on the federal level, but it was not selectable on the state level, which I think is hilarious, figuring that the UCC is not federal law, but it is state law. So, at some point in time, I think what we're doing and the work that I do, there's going to be some sort of point where that's going to have to change. And, I'm probably going to hammer that really, really hard in the city of Glendale case, the utilities case, the other case that I have going on, because, what is the federal court basing their decisions off of? If it isn't the UCC, then what is it? And the answer is it is the UCC. So this whole UCC is not law at the federal level and it's just a model code. That's got to be bullshit. There's got to be more to the story, okay? Anyways, so here is the signature on that cover page addendum. It's not that important. Every state's going to be different. Now, here we get into the complaint, okay? You'll see it looks a little different because we have a different type of court that we're going to. We're not going to a federal anymore with this one. We're just state, and this is just... I'm testing this out because the UCC is law at the state level. And there's no confusion about that. And everyone's on the same page about that. So myself and Joey Kimbrough are pretty excited about this because this is going to be the first time where, we don't need to fight to get that established. The UCC is law. That's what we're going to be talking about. So that makes me very excited because, that's what I'm trying to talk about the whole time, right? So same kind of thing you've been seeing in the federal cases, person, all caps, presented by man, me. That's it, right? We don't need to get anything more on that. So as you guys have seen in the past, like with the MX case, the judge was using these extremely weird, vague, broad generalities that are totally irrelevant to anything that I'm saying in my cases, such as vapor money theory and redemption scheme. So I just start out right away and I just tell them that if they decide to pull some fucking dumb bullshit like that, I'm going to be reporting them to, and I'm not kidding when I say this, I'll be reporting that to fucking everybody. SEC, I don't care. If they have even something anywhere, I'll go to my local DA if I see people writing vapor money theory and redemption scheme on any of this shit. So, I saw the district attorney's office when I was there in the courthouse, and I was like, I'll just go in there and start talking to him about things. Eventually we're going to start getting into criminal stuff. But anyways, so I start off with this. Okay, this is just like, anyone attempting to degrade our law will not be tolerated. I'm just not going to put up with it anymore. Okay, so if they want to play that game, I'll play that game. Okay, we've got the jurisdiction and venue section, right? Just some basic information. This is very, very basic. A thorough breakdown of the parties on the plaintiff side can be found on the original affidavit novation that was sent to SBA, Exhibit A. We'll get into that later. We're going to go through the complaint first before we get into Exhibit A, right? Defendant, Small Business Administration is a federal agency, blah, blah, blah. And then here we start getting into the general factual allegations, right? So all caps, Brown & Jill Williams registered trademark, had a SBA loan, quote unquote. It wasn't a loan, so I put it in quotes. SBA disaster loan application number, loan number for $59,000. The loan was subsequently expanded to $198,700 under the same application number with the endorsement dated December 14, 2021, listing Brandon Joe Williams as the beneficiary. Brandon Joe Williams endorsed the original promissory note with a blank endorsement due to a lack of knowledge regarding the terms and conditions of how the loan would be funded. The original promissory notes, both the initial and the second one, were then funded by the SBA or its agents by endorsing the released original instruments using a qualified and special endorsement, preparing them for negotiation. These instruments were then used as collateral security pursuant to 12 U.S.C. 412. And you'll see some of these are spelled E-N-D-O-R-S-E-M-E-N-T. I don't know what happened. I think there was like a last-minute spell check thing that changed these. I do not ever recommend that you spell it like this. It should always be spelled with an I. And you'll see it later in the complaint. It's spelled with an I. It's kind of a fuck up on my end. I don't know what happened with that. After looking at this thing and thinking about this thing for 4, 5, 6 months, I eventually hit like a breaking point where I just say fuck everything and I just file it and I can't even look at it anymore. And then if there's any problems or issues, then we'll work it out later. It just gets to a certain point where I start getting pissed off, and that's kind of where this case was getting. So I just didn't care anymore, and I filed it, and any issues or difficulties, we'll just work it out as we go. I don't care. Okay. This has been such a long time in the making, and I just wanted to get it done before I freaking explode, rip my own hair out. So, these instruments were then used as a collateral security pursuant to 12 U.S.C. 412, and an application for notes was executed accordingly, or the instruments were traded while still blank endorsed, as they could be negotiated by transfer of possession alone. So the original instruments, when they were negotiated with a blank endorsement, which is what most people are doing and what I did on accident, didn't know, they can actually trade or sell that. They don't have to go to the window. You guys have to realize. That document is basically like a $197,000 Federal Reserve note. They can sell it, they can trade it, they can keep it, they can swap it, they can put it in a fucking drawer. They can do whatever they want, or they can go to the window. When they go to the window, that's when they're going to put the special and qualified endorsement on it. But they can negotiate the instrument by transfer of possession alone, and I think UCC 3-105, 3-104. I don't think it's 104. Let me just take a look here and see if we can find this real quick for you, in case you've forgotten. 3-109. That might be it. Let me pause this for 1 second. I'll find this for you guys. Here we go. So here it is. 3-109, 3-205 in the blank endorsement section. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone until specially endorsed. So they can pass it around like a cheap whore for years until they decide to finally go to the window with it. That's when it's going to be specially endorsed at that point. Okay? So I changed that a little bit because in the previous lawsuits I didn't add that in, but there's actually two ways they can negotiate it. They can just pass it along, blank endorsed, and sell it or trade it or exchange it or give it away, or they can take it to the window. When they take it to the window is when they're going to do the special endorsement, when the swap occurs, right? This is misspelled a little bit. Thankfully, no extraneous or irrelevant payments, overpayments on either of these loans using Federal Reserve notes or any other negotiable instrument occurred. I missed a word here. Occurred, right? A novation affidavit clarifying plaintiff's claim to all original negotiable instruments, as well as several other changes in the contract and unconditional orders to perform via endorsement change and reacquisition of the instruments, was sent to defendant. This document is attached hereto as Exhibit A, which we'll get into a little bit later, right? Brandon Joe Williams, as the agent for the plaintiff, is reclaiming the instruments in accordance with, and now what we're looking at here is we're looking at the state version of the model code. So model code is UCC 3-306, and California, that's in the California Commercial Code, Division 3, Chapter 3, Section 3306. It's the same thing. It's the same wording. A person taking an instrument other than the person having the rights of a holder in due course is subject to a claim of a property or possessory right in the instrument or its proceeds, including a claim to rescind a negotiation and recover the instrument or its proceeds. That's basically what we're doing, right? And I wanted to say something on this. We see a lot of people now sending in promissory notes to try to pay off an account. I don't see why you would do that. That's the same to me as non-performance, because your Federal Reserve notes are also sending in promissory notes to pay off an account. I think both are incorrect. I think it's incorrect to send in a manufactured promissory note, and I think it's incorrect to also send in a Federal Reserve note. I think what everyone should be doing is you should be claiming the property or possessory right, including a claim to rescind a negotiation for the original notes or bills. That's what I'm doing. I'm never going to send in a promissory note or a bill of exchange to any of these people except maybe the IRS, because that's not what I'm trying to do. I'm trying to reclaim the original property that they fraudulently, fraud through omission, did not explain how it worked in its basic form. That's the issue. It's contractual fraud, okay? The original instruments, now that negotiation has been clarified via the novation, constitute payment in accordance with the California Commercial Code, Division 3, Chapter 3, Section 3-603. B. You guys know about that one, right? Now, at this point, we'll go ahead and go through some of these, and then we'll probably jump over to the exhibits. The novation affidavit was signed for in Washington, D.C. on June 26, 2024 at 11:43 a.m., attached hereto as Exhibit A. A second letter indicating the affidavit as unrebutted was signed for in Washington, D.C. on July 10th, 2024 at 11:31 a.m., which is Exhibit B. A third and final offer to perform and notice of intent to sue was signed for in Washington, D.C. on July 22nd, 2024 at 8:49 a.m., attached hereto as Exhibit C. An irrelevant response from the SBA received after both locations had received all three parcels totaling 6 mailings is attached hereto as Exhibit D. That's when we decided we were going to go to state court instead of federal court. So a fourth and final letter, which was a slight amendment to the novation, adding state criminal code statutes into the the contractual relationship as a private right of action, signed for in Washington, D.C. at 12:01 p.m. on September 2024, is attached here to Exhibit E. And we start getting into the various breaches, right? So at that point, we're going to go down to Exhibit A, and I'll show you what the affidavit novation looked like, and we'll cover each point of that now. So we have Exhibit A, right? Just a big, huge thing. Affidavit. It's an affidavit, and it goes over novation, orders, clarification, and statement of value and consideration. That's what we're doing inside of this document, right? From, to, regarding, okay? Definitions. Payment, tender, check, U.S. dollars, novation, consideration, nation, order, promise. Okay, introduction. Thank you very much for reading this. Notice to agent is notice to principal. I'm available via multiple forms of contact if any clarification of this document is needed prior to responding in affidavit form. Novation of points, parties, right? Now, why am I doing a novation for the parties? Okay. Well, the thing is that we can go in there and we can fight about the all caps name and fight about this and fight about that. Why fight about all that when you can just make it a contractual agreement? Now, when you make it a contractual agreement, there's nothing to argue about. There's nothing to argue about what's a person and what's this and who are you and what's the all caps name. It's all going to be entered into the contract as a contractual aspect of the case. Contract basically supersedes whatever's in the USC or anything else. The USC and a lot of the stuff that people fight about, that's all because it wasn't clarified in the contract. If it's clarified in the contract becomes the God, because the judge is just a referee. So You guys are kind of like playing your own little game, and the judge is like the referee, and that's it. So what we're doing here is we're taking our own programming of the whole game, which we do before with having our own definitions and stuff, and we're going even a step farther, and we're making all sorts of aspects and assumptions part of the contractual agreement of the novation. It's very powerful. I mean, obviously this is 2.0. This is all going to be in testing, but I think this is very smart and very powerful and very transparent. The definition of person from 26 U.S.C. 7701 subsection A1 is the term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. The definition of certificate is statement of some fact in a writing signed by the party certifying. The definition of live birth is live birth means a complete expulsion or extraction from its mother of a product of conception, irrespective of the duration of pregnancy, which after such separation breathes or shows any other evidence of life, such as the beating of a heart, pulsation of the umbilical cord, or a definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. A certificate of live birth is a statement that a live birth occurred. Typically, there are aspects of the live birth, such as the placenta, which is abandoned, left for disposal by the mother. This could also be other parts of birth, such as the umbilical cord. State of Indiana is listed as a business on Dun and Bradstreet and is located in the District of Columbia. The evidence behind this is that the United States is located in the District of Columbia as per UCC 9-307 subsection H. State of Indiana is a subcorporation of United States. 4 U.S.C. 72 also covers this idea as well. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. Naturalization, as per 8 U.S.C. 1101 subsection A23, is defined as the term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. The definition of the word person from Title 8 is defined as an individual or organization. The word state from naturalization is synonymous with the word nation, which is defined in the definition section in definition 1 of this novation. The definition of public corporation is a public corporation is one created by the state for political purposes and to act as an agency in the administration of civil government. So we're just getting into the basic definitions there. We're not saying a whole lot, right? Now, here's where we actually novate this whole thing and clarify the parties based off that information. When born, my mother abandoned the various products of conception. These products were part of the live birth, and the certificate of live birth involves only those abandoned products, not the male body of which I possessed and inhabit to this day. The certificate of live birth is a document that is an abandonment and naturalization document. It is a document that shows that products of the live birth were abandoned, and it also is my mother conferring the nationality of the state called State of Indiana upon the abandoned products of conception after birth by any means whatsoever, which is naturalization. This effectively naturalized what was assumed to be me falsely into the District of Columbia. There is a specific line on my certificate of live birth entitled Date Received by Local Health Officer. This date is the date that a public corporation / trust / estate was opened as a legal fiction, which represents the abandoned products of conception. This public corporation / trust / estate is represented by my name converted into a trade name or doing business as name of my name in all capital letters, Brandon Joe Williams. I have a registered trademark on that name, comma, Brandon Joe Williams registered trademark, comma, which is trademark number 97335158 with the USPTO. Any unauthorized use of that trade name will be a cause of action for trademark infringement. This corporation, trust, estate is a person as per most definitions found of the word. The birthday of the person, all caps, Brandon Joe Williams registered trademark, is the date that the certificate of live birth was received by the local health officer, which would be February 14th, 1986. The Social Security number is an employer identification number, EIN-TIN, for the public corporation, trust, estate, and is not attached to the natural person. EIN numbers are assigned to businesses, not men and women. Now here we go on to the next section. Myself, not including any of the above aspects, am a natural person or individual. But those terms are quite confusing and even have some definitions that infer the terms could include artificial fictions, such as corporations, trusts, estates, etc. A good example of the above confusion can be found in this definition of the word individual. As a noun, this term denotes a single person as distinguished from a group or class, and also very commonly a private or natural person as distinguished from a corporation, partnership, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. For clarity of all of our contracts, the term natural person and also the term individual in all aspects of our contracting will be defined as the following. The living man or woman, the man or woman operates and speaks on behalf of the public corporation / trust / estate in the fictional world, but is entirely a different person. This individual or natural person does not fit the definitions in the normal legal world, and this definition specifically and entirely eliminates all assumptions of jurisdiction, citizenship, nationality, etc. All of that information is definable only and exclusively by the individual man or woman and is not subject to any involuntary servitude, forced contractual obligation, etc. I have a state case legally changing my name from all caps Brandon Joe Williams to upper and lowercase Brandon Joe Williams. That was approved by a judge in case 23 STCP 02865. My birthday as a natural person is January 28th, 1986. I operate as the attorney in fact over the person named Brandon Joe Williams registered trademark, and all contact will be made through Brandon Joe Williams registered trademark, including any litigation. I also have a perfected security interest in a UCC1 available on the State of California Secretary of State website by searching all caps Brandon Joe Williams. Conclusion. There are two persons at play here. One is a natural person and the other is a public corporation. The public corporation is used as a buffer or flow-through for the commercial transactions. And it is agreed through this novation that the trade name, all caps Brandon Joe Williams registered trademark, will be the primary person mentioned on all documents and litigation, and then the natural person, Brandon Joe Williams, speaks on behalf of the public corporation because the public corporation cannot speak or write. Brandon Joe Williams will not be the one entering jurisdiction into any court, and he will be using naturalization in order to move Brandon Joe Williams, all caps registered trademark, into the court. But it is agreed by all parties that he is still operating pro se in the courts as he is still presenting in his own name. The agreement is that Brandon Joe Williams registered trademark is a commercial trade name that Brandon Joe Williams is authorized to use in commerce. Brandon Joe Williams is a foreign national of the Nation of the Amnesty Coalition, which can be viewed at amnestycoalition.org. All caps Brandon Joe Williams registered trademark is movable via naturalization as per 8 U.S.C. 1101 subsection A23 and will be moved around at will by Brandon Joe Williams. If a power of attorney for all caps Brandon Joe Williams registered trademark on behalf of Brandon Joe Williams is requested, it will be provided. It is also available for download at williamsandwilliamslawfirm.com. Brandon Joe Williams is not a resident or citizen of absolutely any corporate, unincorporated, or business entity. The plural version of men or women is people, whereas the plural of legal fictions is persons. So we're leaving nothing for any sort of assumption, debate, or presumption. You're putting it all on the table and cornering them. They don't have an option anymore. Okay? Now we're going to get into non-party related points of novation, right? All previous assumed and expressed arbitration agreements are hereby void due to fraud and lack of consideration. No parties are any longer eligible for any arbitration activities, and discovery, right to a jury trial, and all other rights of due process are hereby retained explicitly by all parties. That you don't want arbitration. Arbitration is absolute, complete trash, and you want to kill it, destroy it, and burn anything that could possibly have it mentioned in it at all. If it has the word arbitration, it needs to be burned to the fucking ground, okay? Arbitration means you don't get discovery, you don't get a right to a jury trial, and often it's like retired judges that are actually being paid by the company to do the arbitration. It couldn't get any worse, and it couldn't get any more biased. It's literally trash. And they make it, they fake it to make it look like you're getting justice. It's literally garbage. Point number 2 of the contractual novation. Without prejudice, and the reserving of all rights is hereby activated for both Brandon Joe Williams, all caps registered trademark, and Brandon Joe Williams. All rights are reserved at all times. Number 3, all negotiable instruments, promissory notes, and bills of exchange, including all transactions on all accounts past, present, and future, are hereby novated under fraud. The fraud is lack of clear conditions or terms, fraud, unjust enrichment, etc. All past, present, and future blank endorsements are hereby canceled. All blank endorsements from this point forward need to be explicitly endorsed, quote, paid to the order of bearer, end quote. Otherwise, they cannot be assumed to be blank. The new qualified special endorsement for all past, present, and future securities is now the following. Consideration to all currency exchanges will be paid once performance of Federal Reserve discount window services have been completed and Federal Reserve notes are returned to the payee. That means basically they do the swap and then I'll pay them from the proceeds of the swap because there has to be adequate consideration in order for there to be a contract. Okay. Without recourse, paid to the order of, all caps Brandon Joe Williams, by Brandon Joe Williams agent, Brandon Joe Williams attorney in fact. Now this part here, this is actually Joey Kimbrough's brainchild. Brilliant. All Title 18 crimes, which normally do not have a private right of action in litigation, are hereby entered into this novation as a contractual aspect of our private agreements, meaning that all these codes are now enforceable in a civil court as a private part of our contractual obligations, and these codes are now active to being causes of action in civil court. So for those of you who have been following my cases, I did a lot of Title 18 stuff at the first couple of cases, and it was all thrown out for what's called no private right of action. Basically, you have to go through the DA's office, and you have to get the state to prosecute Title 18 claims as criminal claims. So what we're doing here is we're testing bringing all of Title 18 and actually entering it into the contract on the private side of the contract, which is a beautiful, beautiful idea by Joey Kimbrough, and I'm very excited. And then later on, we added to this. I'll probably put up a template for this so you guys can have it. I'm going to add in here, it also includes any state penal codes, criminal codes, etc., which is, I had to send another novation, an amended novation, which is Exhibit E, because originally we were going to go to federal court, and then we changed that. So it's better to just make this Title 18 on the federal side, and then you can also add in all the state side, criminal and penal. So I would just add that in here. I think I'll probably make this a template, and I'll add that in there for you guys, so you guys have that, okay? So number 5, anything that was previously pledged as collateral on any accounts or loans above and beyond the original promissory note that now has a qualified special endorsement is hereby released and no longer attached as collateral on any accounts. The original note or bill is all they need for collateral. They don't need anything else. They don't need the house. They don't need the car. They don't need jewelry. They don't need anything. They actually are over collateralized already just by having the note. They don't need anything else. All interest payable on all notes or bills are now claimed by Brandon Joe Williams, all caps registered trademark, and Brandon Joe Williams. And that controversy needs to be sorted out right away so we can determine what service fee that any banking or financial organization will be getting for the service of currency exchange at the Federal Reserve discount window, right? So again, I'm claiming everything. Claiming the interest, claiming the swap, claiming the instruments. Everything is mine, okay? If you are a bank, credit union, or any other financial institution, you are hereby now the fiduciary for, all caps, Brandon Joe Williams registered trademark, and Brandon Joe Williams. Your fiduciary duty is to ensure the clean, direct, and honest negotiation of all negotiable instruments and to properly help us do a currency exchange of the original collateral securities for Federal Reserve notes at the Federal Reserve discount window. Absolutely anything that would not effectively and rapidly assist in that is now officially a breach of fiduciary duties. Any usage of the term lender or borrower when attempting to say that you lended either of us anything will be charged with a breach of fiduciary duties. The only thing that is considered consideration in this contract is now the helpful actions that assist us in security swaps at the Federal Reserve discount window. Nothing else is consideration. So you're cornering them. You're defining what is value and consideration because, again, value and consideration define the entire contract. So we are clearly stating what is value and consideration. We are reprogramming the entire spinal cord and nervous system of the entire relationship. There's nothing they can do about it. Now, in all honesty, this should have been said at the beginning, but because of the fraud, we didn't get into it, right? This is an important point. I don't remember why this came up. I just remember like either someone mentioned it or maybe it was mentioned in one of my lawsuits and I wanted to just jump on it. Notarization is not naturalization. And just because a document was notarized in a location does not mean that it is naturalization of any individual or organization. Naturalization is only legally binding if it is a clear and specific conferring of a state, or nation upon an individual or organization after birth by any means whatsoever. As of this writing of this novation, all caps Brandon Joe Williams registered trademark is hereby conferred into the business called State of California, while Brandon Joe Williams confers the state called Nation of the Amnesty Coalition Unincorporated upon himself after birth by any means whatsoever. Brandon Joe Williams is the king of the Nation of the Amnesty Coalition. Okay? So we're getting down the parties. We're getting down the contractual points. We're getting down the locations. We're getting everything clarified and locked down through this novation, right? Section 3, value and consideration clarification. To be clear, all lending was never, this got a little bit misspelled, was never, and is not, I should have clarified that a little bit, considered consideration because there is no lending going on. But facilitating Federal Reserve services at the discount window via an OC-10 agreement is considered consideration. It is valuable consideration that my currency, which is the original note, is being swapped at the window for another type of currency called Federal Reserve notes and returned to me. This activity is not lending, but is a simple currency exchange. This is what it will be called in all aspects of our contract or any necessary litigation. Now, if you guys notice, I'm not asking for anything. I haven't asked them for anything so far. I am telling them exactly how this is going down. There's no debate. There will be no debate. There is nothing. I'm not asking them for anything. No. This is, I am laying down the fucking law with this thing. This is the law. I am the lawmaker. I am the legislation division of this fucking agreement. And there's been fraud, and it's a fraud of omission, and we're not talking about a lot of things, and you guys didn't tell me things, and a lot of people don't know things, and we're just getting it all cleaned up, and I'm not asking you a fucking thing. I am telling you what's happening. I am telling you the definition of the parties. I am telling you the definition of the words. I am telling you changes in the contract that are occurring right now. I'm not asking for anything. You guys have to realize that. If you're asking for something, let's say you want evidence or you want to collect information, you do a FOIA request. That's your evidence collection time period. FOIA request, I need this, I need that. Can you guys send me this? Can you guys send me that? That you're building your case with the FOIA request, right? A novation, you're not asking them anything. I mean, there's orders here, but these are not, I'm not asking them for anything. I'm telling you, you guys are going to do this. Whether you're going to do it without the courts or we're going to do it in the courts, but I'm not asking you for anything. You are fucking doing this. End of fucking story. There will be no debates. There will be no questions. There will be no back and forth. There's no negotiating the terms. No. You are doing this, and I am going to twist your arm until it breaks the fuck off if I have to. That's it. End of story. You guys have to realize that's what this is. Okay? Any usage of the word lending or any indication of being loaned anything will be met with fraud charges. Okay, we're just clarifying that. Very important, right? Section 4, orders. Please discharge, set off all imbalanced accounts and immediately refund all overperformance on this account since the account's inception. Please send me a verified affidavit of this being completed by an individual. Please include their phone number and email on the affidavit as well in case I need to contact them. Please immediately remove any bad reports that may have been made on the credit score of the trade name Brandon Joe Williams, all caps registered trademark. Please remove any accounts from any quote-unquote collections. Please also release any liens or any security interest that has been filed in any way for any asset, and please destroy any certificates of title or any other security showing a security interest for anything associated with our contracts. All assets will now be held in full dominion in private trusts that are located in the nation of the Amnesty Coalition. Do not list the public corporation as a registered owner or release any documentation showing a security interest. Anything issued of this type will be securities fraud and will be handled with litigation, civil and criminal. This includes any interest available from the swapping of any collateral securities at the Federal Reserve discount window, and extraneous and irrelevant Federal Reserve notes that were tendered onto this account, and any additional securitization or activities that took place with any original collateral securities. You have a total of 30 days to complete these orders from the time this affidavit is signed for. There will be a series of other mailings sent to you during this time to ensure proper notice of novation. This document is an unconditional order to perform. It's the most important line, in my opinion. This document is an unconditional order to perform. I'm not asking you a fucking thing. You guys have to realize that. You are going to fucking perform. I don't care if I have to beat the shit out of you for a fucking decade. You are going to perform. You guys have to realize that's how this is going to go down. Section 5, closing statements. This affidavit is being sent to you in good faith. UCC 1-201 defines good faith as, quote, honesty in fact and the observance of reasonable commercial standards of fair dealing, end quote. I would like to be clear that I am absolutely and entirely available for in-person communication, email, phone calls, texts, faxes, or hard mail through the USPS. I am not a combatant and simply wish to establish a more equitable agreement between us where we can both win and succeed. This is an affidavit that is being issued to you. This affidavit must be rebutted by an affidavit specifically clarifying and rebutting each and every individual aspect of which you are not in agreement with, or would like to change, and exact and specific reasoning and supporting laws or statutes must be written in the affidavit in order for there to be a justiciable controversy on that particular aspect. The total time that you are being given to perform on these orders is 30 days from the receipt of this affidavit. If there is a denial of the orders in Section 4, or if these affidavits are ignored, litigation will be filed and served immediately after the denial or immediately after the 30-day period elapses. You may call me, email me, send mail to me, or any other reasonable attempt to contact me, and I'll be more than happy to speak with you. I am more than willing to work with you, and this section is here just to be clear that intimidation, slander, libel, lies, and bluffs will be aggressively handled to the absolute fullest extent of the law. Honest attempts to solve the difficulties and controversies that we find ourselves in will be met with sincerity and appreciation. If executed without the United States, I declare blah, 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 and then here's the notary. Okay. And then we have the 3811 or 3810. What is it? 3811, proving that it was signed by OGC or whatever. Okay. Exhibit B, second mailing. Okay. Notice of unrebutted affidavit. Parcels 1 and 2 was delivered, unrebutted. This is the second of a total of 3 mailings will be mailed to you prior to litigation. Please perform. And then I enclosed copies of that entire Exhibit A, again, when I sent them this second mailing. And then here's the 3811 on that one. And then we have Exhibit C. This is the third and final mailing. This is notice of litigation. Same thing. First round, second round. And then we have, this is the third and final mailing. Please perform. And then I enclosed scanned copies of the original affidavit again on this one. Okay. And then we have the 3011 signed by somebody else, it looks like. Exhibit D, this is a completely irrelevant form letter that they sent me in response to A, B, and C, which is just, it looks like you're having a hard time paying. And they effectively failed to respond to any point of my novation, thus creating a full activation of each and every single point of my novation. So at that point, the entire contract was fully converted into my novation entirely, and that replaced any contractual aspects we already had. And then Exhibit E is a slight amended novation, where I just said that this amended novation also includes any state criminal claims or statutes on top of the Title 18 U.S.C., and this now gives both parties the ability to bring state criminal, penal, or other kinds of claims into a civil court with a private right of action as being contractual via this novation. Because we were going to state court. We decided to change it to state court, right? So that's that. And going back to the complaint. Let's go back up to the complaint here, and we're going to start back at the first cause of action. The first cause of action is breach of contract. Defendant failed to perform the obligations outlined in the novation constituting a breach of contract. Instead of applying the payment to the account and closing it, defendant sent plaintiff to collections amounting to harassment and additional failures to perform or dishonor the instruments, which would be as per 3-502. Defendant failed to perform and failed to dishonor the instrument in accordance with 3-502. So covering that, if we were to go back and looking at this, so when they dishonor the instrument, they can only dishonor it based off of these particular rules, 3-502. It has to be. So a draft can only be dishonored in these ways, and a note can only be dishonored in these ways, right? Dishonor of an unaccepted draft is governed by the following rules, and dishonor of a note is governed by these rules. So these are the only ways they can dishonor the instrument. They pretend as though they can just say no. They can't just say no, right? If they quote unquote just say no, what applies at that point is 3-603 subsection B. So they can choose one of these three, which none of us are going to cause these kind of problems typically, and plus you can cross out the due date and write payable on demand, and 3-114 applies. But regardless of all that, if they don't dishonor the instrument in relation to UCC 3-502, then 3-603B applies. If tender of payment and obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, they're not dishonoring it, they're refusing it. See? If they refuse it, there is discharge to the extent of the amount of the tender or the obligation. So if they refuse it, meaning if they don't dishonor it and they say no, then it applies to the account regardless. Makes no difference. So you guys think them saying no means something. Them saying no means fucking nothing. Oh, we're not going to accept your instrument. That's funny. That doesn't exist. You can't. That is physically impossible. That's like somebody saying, "Oh, okay, I'll just fly up in the air and disappear into vapor and rematerialize on Jupiter." Haha. Okay, cool. Yeah, it's like a joke. It's literally a joke when people tell you we're not going to accept your instrument. They can't do that. I just don't get how you guys don't understand that. That's just like a belly laugh. Like you're in tears laughing so hard. Can't do that. Wow. Okay. The cool thing about litigation is you get tons of fucking damages. So like I get excited when they tell me that they're going to refuse the instrument. It's the best day of my fucking life. Now a quick tip. If they refuse the instrument, you should try to get that in writing. You're going to use that as evidence of 3-603 subsection B. If refused, it applies. So by them saying no, and you get evidence of them saying no, in court, that no is now a yes. Period. End of fucking story. So if you can't get it in writing, that's okay. You can still go into litigation because you can do a deposition and just be like, they're not gonna tell the court like, oh no, we accepted it. If they do, then you just won and you don't even need to fight. That'd be pretty cool. And if they say no, we didn't accept it, well, there you go. Now we've got a conversation about 3-603, and then now we've got damages for having to waste your fucking time. They should have just followed the fucking law. They didn't do it. They didn't perform. Fuck them. Now they need to be disciplined. Go see your fucking DA too. Tell the DA. These fucks are not following the law. They're not performing. It's illegal. Okay? So defendant failed to perform and failed to dishonor the instrument in accordance with the state version of 3-502, right? This breach caused plaintiff anxiety and difficulty, violating 3-603 as well as 3-502. They fucked up badly, right? Breach of fiduciary duty. Remember, we claimed that we named them as fiduciaries. They did agree to that by not responding to the novation. Okay? So there's nothing to debate about that. They are the fiduciary now, motherfucker. Defendant accepted the second note with the beneficiary signature, thus agreeing that Brandon J. Williams was the beneficiary of the currency exchange. Defendant failed to perform the duties outlined in the novation, which carefully delineated their fiduciary obligations, constituting a breach of fiduciary duty. This complaint serves as notice of breach of fiduciary duty in accordance with 3-307. Defendant, fiduciary, failed to apply the payment or dishonor the instrument as required by 3-502, necessitating resolution under 3-603B. Just like I just said, it's one or the other. You guys can either say yes and apply it or say no and then it gets applied. You don't have a fucking choice, bro. These people think they have a choice, and it's just too funny to think about. Man. It's just hilarious. It's like a homeless person like being like, "Oh man, I can't wait to drive my Lamborghini tomorrow," and they're like literally on fucking ketamine, naked, dirty in some alleyway, getting attacked by like fucking sewer rats. It's absolutely hilarious. It's ridiculous, delusional, insane, and kind of sad actually. It's kind of pathetic and sad actually. It's like, oh, you think you can say no to the tender of my instrument? Oh, you're so cute. Little cute fuck. So now we have the next one, money. So money had and received is a tort claim, right? But we're not talking about money. So I just added the word currency in here, right? And you'll see why, the word currency is added to this cause of action because we are absolutely, in all caps, positively, entirely and completely not talking about money at all. 3-102 states, A, this article applies to negotiable instruments. It does not apply to money. We are not fucking talking about money. And I swear to God, I swear to fucking God, if I hear anyone say the word money during these proceedings, I am going to fucking freak out. Objection, and I will object. I don't care if it's sustained. I don't care. I will object violently over and over and over. We are not talking about fucking money. Objection, irrelevant. Objection, irrelevant. Objection, irrelevant. Objection, irrelevant. Objection, irrelevant. Objection, irrelevant. We are not talking about money at all. I don't want to talk about something that has absolutely nothing to do with what we're trying to do. I don't want to waste my time, and I don't want to waste the court's time. We are not talking about money, and we will not be talking about money, Your Honor. If the judge says it, I'm going to go. It's the one thing that's going to piss me off. You can call me a sob sit all you want. That's not really going to irritate me that much. You start saying that I'm talking about money, that's going to piss me off. We are not talking about money. It's fraud on the court for you to start using that word. And I will file for sanctions. I will file fucking bar complaints. We are not talking about money. You are misleading the court. It's fraud on the court. We are not talking about money. Very aggressive. The original notes constitute the currency in question. Plaintiff possessed these notes prior to endorsement and negotiation. Had plaintiff been aware that the note would fund the loan, he would have endorsed it with a qualified and or special endorsement. Defendant had a duty to ensure that plaintiff understood the terms of the contract. This gross negligence resulted in the value of the original note being released without condition. rather than being applied to zero out the account after the currency exchange, effectively enslaving the plaintiff. Right? Peonage, debt slavery. Plaintiff incorporates by reference. That's just a normal one. Defendant had a duty to inform its borrowers, who are not actually borrowers, about how the funding process works, i.e. that the borrower funds their own loan. Defendant failed to disclose to plaintiff that the original note would undergo a currency exchange to fund the loan. The omission constituted fraud, creating a false peonage situation by making all caps Brandon Joe Williams registered trademark believe he needed to work or acquire negotiable instruments called Federal Reserve notes from unrelated sources to perform on this account, which is grossly misleading. Conversion, fifth cause of action. By failing to inform all caps Brandon Joe Williams registered trademark of his endorsement options, defendant unlawfully gained control of the valuable original negotiable instruments through unknowing blank endorsements. Defendant's actions deprive plaintiff of his property rights in the instruments. Sixth cause of action, unjust enrichment. Defendant used the original promissory notes negotiated under fraudulent blank endorsements to fund the loan by exchanging the instrument at the Federal Reserve discount window pursuant to 12 U.S.C. 412, or by selling or trading the bearer security through transfer of possession, which is what we saw earlier, 3-109, I believe it was, right? Essentially, plaintiff funded his own loan, and defendant was unjustly enriched by this process. This process was deliberately obscured to make it appear as though the bank was lending negotiable instruments to plaintiff when it was merely facilitating a currency exchange between different types of negotiable instruments. Okay? If you guys watch the whole course, you should understand this pretty well. I'm not going to get into some of this stuff. Seventh cause of action, unfair, unlawful, and fraudulent business activities. Defendant engaged in unfair, unlawful, and fraudulent business acts by misappropriating the original notes and failing to disclose material information regarding the funding process. The original notes, once the novation affidavit went unaddressed, are considered stolen negotiable instruments. Discovery is necessary to trace the location and negotiation of these instruments and to determine any monetary securitization that has occurred. Plaintiff is entitled to restitution and disgorgement. I think that got added through some kind of requires a party to give up profits or other gains that were obtained illegally or unethically. Okay, perfect. Is entitled to restitution and disgorgement of all profits derived from the securitization of the original notes and any additional profits or secondary actions derived therefrom. Eighth cause of action. Private right, this is transportation of stolen securities, which is a penal code point, and then private right of action is available due to an acquiescence of Exhibit E, because it's contractual now, see? The original notes after the novation affidavit was ignored are deemed stolen negotiable instruments. Defendant knowingly received, concealed, or withheld property that was stolen or obtained by theft in violation of California Penal Code, Section 496, subsection A. Plaintiff is entitled to triple damages pursuant to 496, subsection C. Right. Ninth cause of action. Securities and commodities fraud. Private right of action is available due to the acquiescence of Exhibit E. Defendant misappropriated the original notes through blank endorsements and used them as collateral security to fund the loan. Through fraudulent means, defendant caused plaintiff to unknowingly fund his own loan, thereby violating California securities laws. 10th cause of action, human trafficking, peonage, slavery, which is what we saw in 18 U.S.C. 1587, I believe it is, and then also 42 U.S.C. 1994, which is the civil side at the federal level. I forget exactly, Title 18, 1588 or 1587 or 1582 or something, I think is the Title 18 on the peonage. I need to look that up again. Defendants, this is the state level on this one. We're doing the state on this. Defendant's deceptive practices led plaintiff to unknowingly fund his own loan, creating an illusion of indebtedness and illegally placing him in a state of debt slavery in violation of California Penal Code 236.1. 11th cause of action, grand theft. This is, I think, theft over $10,000 or something like that. Private right of action available due to the acquiescence of Exhibit E, and then through unknowing blank endorsements, a result of defendant's failure to inform, fraud by omission. Defendant effectively stole the original notes from plaintiff by depriving him of the opportunity to apply qualified or special endorsements. Right, and then here's where we get into demand for relief. Full discharge of all loans in their current state. We're going to get into discovery to determine how the original promissory notes were securitized after being unknowingly released for negotiation via blank endorsements, and for all profits derived from such securitization to be awarded to plaintiff as additional damages. We have $2 million payable in negotiable instruments called Federal Reserve notes, or another currency to be exchanged by the court at the Federal Reserve discount window for Federal Reserve notes. And then alternatively, the defendant agrees to sign a limited power of attorney with plaintiff to open a revolving credit account with no credit limit, permitting defendant to execute qualified, special, or restrictive endorsements on all instruments in an unlimited credit functionality. This agreement would entitle defendant to the interest on said generated instruments to establish adequate consideration. This option would eliminate the need for the $2 million in damages specified in the previous paragraph and obviate the necessity for discovery to locate all securitization that occurred on the original promissory notes. For restitution and disgorgement of all profits obtained by defendant through the wrongful acts alleged herein, for triple damages as allowed under 496C, and then for other and further relief as the court deems just and proper. Okay? So that's what this is. This is everything that I've taught you in the entire 2.0 course, all put into one package. So I sent off the novation. You know, this was sent off back on June 20th. So you can see here we are. This thing was filed September 20th. And June 20th is when we started. And it was a bit sloppy because we ended up transferring it to state rather than going federal with this one. So, there's some time in there. I kind of wanted to get it all going and popping after the 30-day window, after they signed for it. It took me a little longer to put everything together than I thought. I reviewed this many, many times over. So you can see here from June. So we have June, and then we have July, August, September. So we're looking at about 3 months. A lot of it is just waiting, right? Because I sent the first letter, and then I waited a few weeks, and then I sent the second letter, and then I waited a few weeks or a couple weeks, and then I sent the third letter. I waited a week or 10 days or something in between each one. So then after that, you're pretty much ready to go. But I waited a little while longer, and I'm glad I did because I got that response, that irrelevant response in Exhibit D. I got this back, which is great. This is what you want, something like Exhibit D, because Exhibit D shows that they did receive it. This is evidence of receipt. Doesn't matter what they say. It really doesn't matter what they say. You guys think that what they say matters. It doesn't matter at all. Getting a response is perfect. It's just, this could just say evidence of receipt, and that's the whole thing. That's basically all I see here. I don't see any other words here. It's all irrelevant. It's objection, irrelevant. Everything in here is irrelevant. It's like they sent me a letter that's written in Cantonese that's talking about an amoeba, a special kind of amoeba that has difficulty going through mitosis when placed in various types of liquids such as hydrogen peroxide or rubbing alcohol. That's how fucking irrelevant everything in this fucking letter is. It's completely, they're talking about the thickness and color of the hair of llamas in Asia. It's just like, okay, wow, great. So you received a letter. Thank you. That's it. That's all this is. It doesn't mean anything. You guys get so fucking weird about it. Doesn't mean anything. It's just like, oh, thank God. You want to save whatever they send you. Make sure you don't get anything on it. Don't spill anything on it. Don't touch it with your grubby fucking hands and get weird smudges on it. Treat all this stuff with a lot of respect, a lot of appreciation. It's evidence. How does the police handle evidence? They use gloves and they put it in Ziploc bags and it's stored in a basement where they control the humidity and they control everything so that these things don't degrade. That's what you want. This is just evidence on a crime scene. That's all this is. Not a big deal. Don't get smudge marks on it. Scan it into the computer right away. Don't lose it. Don't lose the original. You probably, I don't always do this. I should do it. You should save even the original letter that it came in. That's all evidence. Okay? So you're going to do the novation. I recommend that you add just in case you decide you can go state or federal, just add it in. Add the state and the federal penal and criminal codes in to the original novation, okay? That way you don't need to fuck around with this secondary amended novation like I did, okay? So it's not going to hurt you to put both in there. You can always decide at the very, very end if you want to go state or if you want to go federal. The nice thing about state is you can go to your local courthouse and you can go to your pro se clinics. You can go to the reason why I don't teach a lot of the procedure and stuff is because you guys can do pro se clinics, Los Angeles, okay? Federal pro se clinic, and then they also have pro bono self-help clinics in UCLA. They have clinics, well, it looks like even the fucking schools have clinics. You got more clinics than you know what to fucking do with, okay? And the county clerk, so Glendale County civil clerk, her name is Teresa. Let's see if she pops up on here. Maybe she was there. No, it's the city clerk. I wonder where the civil court. Let's see here. Yeah, this is it right here. View website. Okay. What do we have here? lacourt.org. Okay, this is for like e-filing and stuff. So they don't give you a lot of information. Anyways, her name's Teresa. Okay, you can call in there. Okay. I went in there. I had the wrong summons. She gave me the right summons. She told me, they're not going to give you legal advice, but they'll tell you, this is where you write the name of the defendant. This is where you write your name. This is where you put your address here. That's not legal advice, okay? So they'll help you fill these things out if you don't know what court do I go to and like which court do I write at the top of the document. You don't need my help for that. And plus it's too much to try to explain to everybody because it's all the different states and counties and websites. You go to your local pro se clinic for federal or for state. You go to your local courthouse, go to the civil filings or civil cases section and speak to the clerk there. Okay, you can figure all that out. It's very easy to figure all that out. Okay, you can ask your clerk too, how do I file in propria pauperis? Where's the petition for that? She'll give you that too. I'm sure. I didn't ask for that, but I'm sure she'll give it to you. So that's all easy. Where do I go and where do I file and how do I do this? And as long as you get the complaint written and you have your causes of action and you know kind of what you want to sue for and you know the related codes and stuff that go with it and you've got your evidence collected, I'm telling you, I know a lot of the procedural stuff can be very, very complicated, but I'm telling you it's the easiest part because you have a lot of resources that can help you. The problem is you don't have a lot of resources that can help you with your actual complaint. That's the issue. And the issue is you could probably go to like a local law library or something, but typically they're going to start to say things like, we can't give you legal advice, which means we can't tell you how to structure your actual argument. That's what that means. Can't give you legal advice. We can't tell you or recommend or give our opinions as to how you're structuring your argument or your causes of action or your evidence, right? Like a question like, does the evidence go on top of the complaint or behind the complaint when submitted into the court? That wouldn't really be legal advice. That would be a procedural thing that someone at the court could answer for you. Do I put the summons on top? Which summons do I use? Where do I write my name on the summons? These are all non-legal advice questions. Which causes of action do I use? That would be legal advice. Can I sue for this particular thing that occurred when I got pulled over? That would be like legal advice. You see? So as long as you understand the differences, you're kind of on your own when it comes to, a lot of this stuff, when it comes to the structure and the complaint and the codes and the evidence collection and the way everything's laid out. Like it's your argument, bro. People shouldn't be giving you legal advice. It's your fucking argument. That's why I get so pissed off all the time on all the comments and everything, because you guys want me to decide everything for you. It's like, bro, you're going to be involved in litigation for forever, for years or months. I'm not going to be there to jerk you off the whole time. That's why I get pissed off, because it's like, if you're asking me questions now, if I answer them, then I'm going to be fucking running the whole case. Because if you can't make decisions on the front end, it might get a whole lot hotter in the middle. And then now what? Now you're still not going to make decisions? You're just going to get steamrolled. So you guys have to understand that you have to put together your own complaints. You can take your time. I think about this shit for months sometimes before I file a complaint, right? So you can go as fast or as slow as you want, and things can be added to the complaint later. You can add defendants. Let's say you're in discovery and you find some information and you find out there's this other party involved. You can motion the court to add a new defendant, and you can drag that motherfucker right in. So, and then you can add causes of action, and you can even rewrite your complaints, usually one time. If you do it more than once, you have to get it's not really like the most amazing thing in the world. You can see in my 1.0 cases, I rewrote all the complaints once. So, and some of them didn't even need to be rewritten. I just didn't realize that at the time, and I got confused. So I rewrote a lot of the complaints. So realize that you can change a lot of stuff once you just fucking pull the trigger and get rolling. You can add defendants. You can do this. You can add time if you need like an extra month somewhere. You can ask for what's called an enlargement of time and just put some time in there to think about things. You can add in causes of action. You can take out causes of action. You can do so many things. You're better off just pulling the trigger and going in there and trying to do the best you can and move things around. And if you lose, you're going to learn a lot, just like I did. And then now you're going to go up to bat a second time, and now you're going to have way more knowledge and information. You'll do a lot better job. By the second or third or maybe fourth time, it's not going to take you 6 or 7 times. I'd say by the third or fourth time, you're going to have yourself a decent case. Not to say that your first 2 cases might not be very good, but by the third or fourth, you're going to be like pretty solid. You're going to know what's going on. You're going to have a lot more confidence, and you're going to be able to kind of flow and move with the court a lot better. So I recommend you just go for it. File it in. I know it's nerve-wracking or might feel nervous, but you will learn a lot just from the activity of doing it. Don't allow yourself to just think into an oblivion, which can happen with a lot of people. Think for a while, and then when it starts to kind of grind or doesn't seem to be going anywhere, or you're just not sure anymore, just go for it, and it'll work itself out as you go. Coming from a guy who's done it, I'm on my, I think this is the 8th or 9th case that we're on. We've got 10 more we're working on. Okay. So, maybe not quite 10, maybe like 8 or 9, but, we got credit repair coming down the pipeline, which is a very stupid term. You're going to see the way we're going to do it. We're going to just blow these guys to smithereens. It's not really going to be credit repair. We've got 5 mortgages coming down the pipeline, 5 more because I already have 1. And then we've got my own personal credit stuff. We're going to start going after all 3 credit agencies. I know there's a bunch more, but we're going after the 3 big ones, the 3 main ones. We're going to do my own on that. And then the DMV. The DMV, I know you guys are excited about the DMV. It's going to be a while before that one. That's the one that I'm just still not entirely sure. I think about it all the time, and I'm still just not super sure exactly how that's all going to go down. So the DMV is on the slate. I'll probably do all of the 3 credit bureaus first. We'll probably do the 3 credit bureaus. We'll probably do a county. We're doing 1 county for a client. And then we'll probably do the 5 mortgages before you'll see me do the DMV. And I think all those are going to happen this year. The DMV is probably going to happen next year, 2025. Probably the first quarter of 2025, if I had to make an assumption. I just don't want to... I want to feel good about it. I want to really make sure I understand it. I want to really nail it on this one. So anyways, I know I didn't talk a whole lot about this 2.0 litigation. I mean, I think it's pretty self-explanatory. You guys should have a lot of it down. But I hope this was helpful, and I hope you guys kind of see the vision here, making everything contractual through innovation and just laying everything out. There's no surprises. There's nothing to fucking talk about now. Now we're in the court case, and it's just like, hey, why didn't you perform? There's nothing to talk about. We're not talking about the parties. We're not talking about the agreements. You've already done all that. It's already a done deal. It's like pre-trial, setting everything up. You're setting everything up to bring them in and just knock them down. To me, it's very simple. We'll see. I mean, this is, I don't know if anyone's ever tried this before, but to me, it makes sense as to set them up and knock them down kind of a situation. So we'll see. Maybe it won't be. Maybe it'll be a fucking disaster. I don't know. But I'm very excited about it. It makes full sense to me. As far as I'm concerned, it seems to fit every aspect of the law and the definitions of the words and everything else. So I think it's going to work out great. And I recommend that you do this if you want to move forward on these things. And I'll see you guys later. I'm glad you guys are enjoying 2.0. See you guys later.